What is a pretermitted child, or an omitted child? A pretermitted child simply is a child who is born to a decedent after the decedent's will or trust was created or amended. As long as there's no estate planning document created after the child was born, the child may file what's called a petition to determine heirship to establish the child's right to his or her intestate share of the decedent's estate. California Probate Code Section 21620 outlines the rights of a pretermitted or omitted child. How do I prove I'm omitted or pretermitted? Generally, it's clear and obvious when a child is pretermitted. In fact, in many of these situations, the fact the child was omitted may not even be disputed, or lead to a dispute about what the child is entitled to. This is because in most situations, it's simply a case of a will or trust predating the child's birth and not having been updated after the birth. If the child's pretermitted status is disputed, then the omitted child simply needs to file a petition to determine heirship with their county probate court and establish that he or she was born to the decedent after the estate plan was created or amended. Probate litigation counsel should be contacted early to assert the child's rights, which can often help avoid costly and drawn-out legal proceedings. Many situations are complicated by the fact that the omitted child was unknown to the decedent's spouse, and perhaps even his or her other children. For example, a child that was born out of wedlock, known to the decedent but unknown to the decedent's spouse. These children are often omitted but have the same inheritance rights as the decedent's other children. These unknown children scenarios are factually intense and require analysis of the factual and legal merits to determine whether the child may be able to recover anything from the estate. Counsel should be consulted early to determine the best course of action. How much does a pretermitted or omitted child inherit? Under most state probate laws, a pretermitted or omitted child will receive the same amount they would have had there been no will or trust, also referred to as a statutory share or an intestate share. For example, if they are the only child and there is also a surviving spouse, the child may receive up to 50% of the estate assets, and the spouse would receive the other 50%. How do I get my inheritance as a pretermitted child? The first step is to consult an estate litigation attorney who can examine your claim and advise you on how best to proceed, whether that's by contacting the estate administrator or trustee or proceeding straight to court. If court is the best next step, your attorney will help prepare and file in the decedent's county probate court a petition to determine heirship. This notifies the county probate court charged with overseeing the administration of the decedent's affairs, as well as the decedent's other heirs, that you are making a claim against the estate. Filing the petition will begin the legal process and give you a mechanism or a path to ask for an amicable resolution of your claim or settlement, or to secure a judgment if the case goes to trial. This process should be handled in consultation with a probate litigation lawyer to ensure the best result. It's also important to consult with a probate litigation attorney as soon as you learn of the decedent's passing to ensure that your claim is filed timely and before the decedent's estate is distributed to his or her other heirs. If you file your claim after the estate has already been distributed, you're going to have a harder time collecting what you're entitled to. It's going to take a lot longer and it's going to cost you a whole lot more. What if I've been disinherited? In most states, including California, a child can be legally disinherited by a parent, which would leave you with no rights to any estate assets. If you've been disinherited, you may have a claim to contest or challenge the disinheritance. For example, if the disinherited child feels they were disinherited due to the undue influence of the decedent's spouse, or another child, or a third party like a caregiver, then that disinherited child has legal grounds to contest the will. These are highly emotional and complicated factual scenarios. If you have any questions about having been disinherited, please call for a free consultation. We'll walk you through it. We're happy to do it. When should I contact a probate litigation attorney? Generally, the sooner you contact a probate litigation attorney, the better. Getting your rightful assets as an omitted child is much faster if everything is figured out before any estate assets are distributed to other heirs and beneficiaries. It takes longer and is more costly if you're chasing your inheritance and having to claw it back from other heirs, family members, beneficiaries who've already received those assets. How much does a probate litigation attorney cost? While probate litigation can be expensive, many lawyers, like here at RMO, offer alternative fee arrangements, including contingent fee and hybrid fee arrangements. Don't let the fear that you can't afford it deter you from taking advantage of a free consultation with a probate litigation attorney who might be able to help. Do I need a probate litigation attorney near me? We recommend finding an experienced probate litigation attorney familiar with the county probate court where the decedent lived. For example, if the decedent lived in Los Angeles, we recommend working with a probate litigation attorney in Los Angeles, who's more familiar with the Los Angeles County Probate Court than an out-of-area attorney. At RMO, we help people like you address issues like these every day. Have questions? Give us a call or shoot us an email. Consultation is always free. Thanks for watching.